Vybz Kartel made a statement and the judge ignored it. I did not kill Lizard, neither I sent anyone to kill Lizard. All of that coming up in this video. This video was brought to you by TVJ.
Free will boss.
Made it born as a discipline child. Never know when I got so wild. In a this game where the youth them live. Society no do nothing positive. Get to you now get no justice. The system no provide no work for me.
Up first this evening, lawyers for Vybz Kartel and his co-accused are blasting retired High Court Judge Justice Lennox Campbell for not treating the popular entertainer's outright denial of any involvement in the murder of Clive Lizard Williams fairly.
Kartel is appealing the life sentence imposed on him in 2014 for the 2011 murder. Sean Campbell, Andre St. John and Kahira Jones were also convicted. TVJ's Vashon Brown has been covering the appeal and now joins us live. Vashon?
Thank you, Archie and Doreen. Well, it was the fourth day of oral submissions by lawyers representing the appellants. In fact, fourth and final day. Come tomorrow, we will hear the response from the prosecution, led by Senior Deputy Director of Public Prosecutions, Jeremy Taylor. Now today, the trial judge's summary to the jury was again under scrutiny.
Vybz Kartel, in his unsworn statement in the 2014 trial, said, "My lord, my hands are clean of Clive Williams's blood, my lord. If indeed Clive Williams is," the judge said, "if indeed Clive Williams is," Kartel responded, "is deceased, my lord. I have never sent anyone to kill Clive Williams, my lord, nor did I do it myself, my lord. I'm an innocent man, my lord." Attorney at law Oswest Senior-Smith, who is representing Andre St. John, told the court that this outright denial by Kartel was not given sufficient weight by the trial judge in his directions to the jury. He argued that the strength of the statement was diluted significantly and was detrimental to Kartel's case.
Based on much of the issues that were raised in the statement, in the immediate defense of Mr. Palmer, that to my mind, in my respectful view, those issues merited more careful and substantive directions from the learned court at trial.
The other issue, according to the lawyers, is about the judge's direction on inferences. The judge, in his summary of the case, told the jury that, "I must remind you that it is not everything which has to be proved can be proved by direct evidence. That is, you cannot always find a witness that can come and say, 'I saw this' or 'I heard this.' Some things have to be proved inferentially, that is, by drawing an inference from a fact you find proved." He continued, "The law permits you to draw inferences, but the law says you must not draw an inference from a set of proven facts unless that inference is reasonable and inescapable. You draw an inference either to establish guilt on the one hand or innocence on the other."
The issue as to inferences was really whether or not the directions given or the instructions given to the jury by the court were accurate or sufficiently salutary so that they could have applied those directions properly to the evidence that was adduced by the prosecution for them to have come to a fair and considered verdict.
The prosecution's argument is that Kahira Jones and Andre St. John were part of a common design, meaning they all intended to kill Clive Lizard Williams. Jones is accused of holding Lizard from behind, and St. John is accused of holding a block over Lizard's motionless body. The trial judge, in summation, said the prosecution was relying on circumstantial evidence to prove the case. The judge said the first of these circumstances is that there was a common design to kill the men responsible for the loss of the guns and for failure to return them before 8 o'clock on the 14th of August 2011. Mr. Senior-Smith says the trial judge was wrong for saying this because the evidence did not support this. He said having a block by itself does not indicate an intention to kill, neither is holding anyone from behind. He told the court that there is an evidential gap.
The evidence was not the same in relation to all the defendants. And I was saying that if the evidence was not the same, then certainly common design was not applicable as a legal concept to all of them.
Now, attorney for Kahira Jones, Robert Fletcher, also made submissions to the court today. Mr. Fletcher said that the supporting agencies of the state in this matter were loose, lacking and inept, leaving the prosecution with no choice but to roll out a case with what he called deep contamination to lead the trial judge into repeated management confusion. He also argued that the sentences handed down by the trial judge were manifestly excessive. Mr. Fletcher argued that the trial judge failed to gather information in respect to a social inquiry report on the men to come to an appropriate position on the sentencing scale. You will remember that all four were given the mandatory life sentence, with Kartel ordered to serve 35 years before he becomes eligible for parole. Campbell, Jones and St. John were each ordered to serve 25 years before they're eligible for parole. Remember that come tomorrow, we will hear the response from the prosecution. Archie Doreen, back to you.
Thank you, Vashan. To another issue now, Jamaicans for Justice is taking Kensington Primary School and the Ministry of Education to court after issues were raised as to whether a child could be barred from school for wearing locks.
The human rights lobby group said the action is to bring a resolution to a matter which has dragged on for too long. Dashan Hendricks has this primetime news follow-up.
At the center of the dispute with the Kensington Primary School in Portmore St. Catherine is the hairstyle of Shireen Virgo's daughter. Miss Virgo is concerned her child could be barred from being educated at that particular institution because she has locks. On a Thursday, she sat with us, telling us she is seeking a resolution to the issue.
I'm advocating with Jamaicans for Justice right now to have this issue sorted out from the legal aspects of it. It's no hard feeling, and it's nothing personal with the school.
Jamaicans for Justice says it approached the parents of the child after the issue hit the media last week, not to get at Kensington Primary School or its principal, but to get a resolution to an issue it believes is in clear contravention of the country's constitution.
And so JFJ has filed a court action in the Constitutional Court seeking declarations, orders and damages from Kensington, against Kensington High and the Ministry of Education, that such policies that ban locks violate several constitutional rights, including the right to education by children, equality before the law, freedom from discrimination, and the right to equitable and humane treatment by public authority.
He said that the matter needs to be settled once and for all. The court is not only being asked to declare that barring locks in schools is unconstitutional, but also that any similar policies are as well. Mr. Malcolm said the hope is that the matter will be heard quickly. He said while schools have the right to set rules, those rules should not be unreasonable, arbitrary and discriminatory, before adding that the Constitution gives the right for every child to get a publicly funded primary education, and anything limiting that right has to be demonstrably justified.
And so what we're asking the court to say is that saying that you don't like locks does not mean that you can restrict access to education, but moreover, it would result in a discriminatory and unequal treatment by public authority, which is also a right that persons have a protection from.
The school said the rule against locks was set for health reasons, the principal not wanting an outbreak of lice.
There have been numerous reported, and you can just go on social media to find the responses from yesterday about this, reported lice outbreaks in several schools where there no locks were involved. Second, locks don't result in a public health crisis in schools. It's a myth, and it's rooted in the discriminatory attitudes we have to African natural hair.
Meanwhile, Ms. Virgo said the school was aware of her daughter's hairstyle long before last Monday when an issue was raised. She also disputed the claim that she agreed to pull out her daughter's locks. Ms. Virgo said she only told the principal she would consult her partner, and after doing so, decided her daughter's locks would stay, as is her desire for the child to be educated at Kensington Primary. You have no concern as to say whether or not the school accepts your child, that there'd be some sort of an issue with the relationship between you and the teachers going forward?
No.
Education Minister Royal Reid told us the school has to accept the child as is, and said a grooming policy to deal decisively with the matter will be outlined before the new school year. Efforts to get a comment from the school proved futile. Dashan Hendricks, TVJ News.
The Human Resources Manager at Petrojam is defending her compensation package and reputation as the scandal hit state entity tries to rebound.